Did this company build its plant in Union-free South Carolina in retaliation, or was it a smart business decision? Peter Barnes has that story from outside the courthouse. He is in Seattle for us. Peter, what is the update right now from the courtroom, sir?
Well, right now, Cheryl, they're just going through a lot of procedural stuff in the courtroom as this administrative hearing gets underway with the NLRB. But one of the groups that is watching all of this right now is the National Right to Work Foundation. We're joined by the president, Mark Mix. And Mark, your organization fights for the rights of workers to join unions or not. Why is this case so important?
Well, it's important, Peter, because we have three clients that we'd hope would be in the courtroom today giving their side of the story as it relates to the siting of the Dreamliner production facility in South Carolina. The ALJ, the administrative law judge, has denied their motion to be heard.
This is three workers in South Carolina.
That's right, who actually will lose their jobs if the NLRB wins this case and they apply the remedy in the case that these 1,000 jobs in South Carolina have to come back here to Washington State.
So what is the implication of this case for corporate America?
Well, I think it has significant implications on relocation strategies of businesses looking to expand and to invest money in other states. I mean, if you're a company and all of a sudden there's this hint of retaliation, alleged retaliation against a union, somehow you're going to end up in a legal battle. This battle may end up at the Supreme Court 2-3 years down the road. So the instability it creates kind of keeps people in place and is really a hindrance to creating jobs in America at this time when we need them the most.
But what about the argument of the union? The union is saying, hey, we don't mind that Boeing wants to open a plant in South Carolina. It says that the company, by doing this, is threatening the union here, and that will have an impact on future contract negotiations, that workers here, if they're afraid they're going to lose their job, may make concessions they might not otherwise make.
Well, that's right. The NLRB...
And that's against the law.
Well, that's right. There are laws about labor law that relate to that kind of thing, but I don't think this case has that. The Solicitor General, the ALJ up there, or excuse me, the NLRB representative, and the lawyer for the unions indicated that it was a transfer of jobs. I don't think that's true. The facts say that the workers here in Washington State are better off than they were when Boeing made this decision. More workers have been hired here. There's been no transfer of work. This was an increase in the production capacity of the 787 Dreamliner, and they made a business decision to go to the right to work state of South Carolina, and the Machinists Union and the AFL-CIO have a problem with that.
All right, Mark Mix of the National Right to Work Foundation. Thanks for joining us today, and you'll be back up there in the courtroom.
Absolutely.
All right. Cheryl, back to you.
Peter Barnes, live for us.